Good morning. My name is Aaron Futterman. The law firm name is Futterman, Lanza and Block, and we're a law office specializing in estate planning, Medicaid applications, and ancillary services related thereto. I'm going to talk this morning about revocable trusts. And revocable trusts are a type of trust, and I get calls all week long regarding the need for a trust. And people say, Aaron, I need a trust. And I say, well, that's super. There's about 59 different types we prepare. Which one do you need? And generally, what I'm leading to is, what's our goal? And a lot of folks are trying to pass their property and avoid probate. And a revocable trust is a type of trust that will avoid probate. I have to warn folks that do have them or are interested in them that these do not provide Medicaid asset protection features. The main reason one would use a revocable trust is if they're interested in keeping things private when they pass their assets to their kids. A trust avoids the publicity that a will does. It's a public record, and anyone can go in to the surrogate's court of a particular county and find out what was in your will, who it was left to, etc. That's one reason, privacy. The more likely reason someone would use a revocable trust is if there's a child, perhaps, that is not being treated equally. We may want to use a trust. If we had used a will to leave this person's property, it opens the door for a will contest. It's an open forum. The child gets an invitation to court and an opportunity to object to the disposition of assets. A trust avoids or eliminates or minimizes this possibility. And then the other reason, another likely reason to use a revocable trust, is if a client has assets out of state. If a New Yorker has a Florida place and they want to leave this property to their children, if we simply used a New York will, Florida feels a little funny about a New York will disposing of their land. So we need a trust to minimize or avoid aggravation in the form of an ancillary probate proceeding, where the executor would have to go through probate in New York and then down to Florida to transfer the Florida property. We can minimize a lot of the expense and aggravation by simply using a revocable trust.